Now let's talk about this. Someone asked a question, and the question is, I got my girlfriend pregnant. I'm not ready to marry her. Can I claim the child? My brother, the answer is no. Marriage is the legality upon which a child is based. If you're not married to a woman, you can't claim that child to be yours, in as much as biologically that's your child, but legally, especially when the woman don't want you to come close to the child, you can't really claim that child. So if you want to claim the child legally, then go marry her.
Everything said in this video is a lie. Total lie. Marriage is not a condition for claiming your child. What matters is not marriage, but paternity. You do not need to marry the mother of your child before you can be recognized as the father of that child. Once you acknowledge or prove that the child is yours by admission, the name of the child, or even DNA, where there is dispute as to the paternity of the child, you cannot be denied the paternity of that child by anybody, not even the mother of that child. Even though they say only the mother of a child knows who the father is, today DNA can also tell you who the father is. As a matter of fact, court can declare who the father is. If there is dispute as to the paternity of the child, DNA can be conducted. The court can order that the DNA be conducted. What matters in determining who the father is not marriage. What matters is paternity. If the mother is denying that you are not the father, you can approach a court so that the court can order a paternity test, not maternity test. Usually, the custody of a child is always awarded to the mother. However, in some instances, courts have denied mothers the custody of children. This is usually a rare occasion where it can be proved that that mother is not fit for whatever reason, maybe for mental health reasons or for moral reasons, for character reasons and all of that, to be in custody of that child. The court will usually want the mother to be in custody of the child. But in all of this, court will usually allow the father access to that child, and that is what? Reasonable access to that child. Either during holidays, during weekends, during special ceremonies, as the court deem fit. What usually matters to the court is the welfare of that child and not whatever exists between the parents. The court cannot, the mother can also not deter the father from coming close to the child. The mother can choose to not want to see the husband, but the mother cannot choose for the husband not to see his child. If, therefore, you have a child and the mother is refusing you access to the child, go to your lawyer. Your lawyer would approach the family court or the high court, depending on the circumstance, to pray for the court to order the woman to allow you access to that child. That is what the courts will do. But the moment you have access, what it means is that you are signing up for what? Care of that child. You must provide for the maintenance of that child. The child, and not his or her mother. I hope you have learned something. Washiri.